Oklahoma Water Resources Board. The Oklahoma Water Resources Board, OWRB, is an agency in the government of Oklahoma under the Governor of Oklahoma. OWRB is responsible for managing and protection of the water resources of Oklahoma, as well as for planning for the state's long-range water needs. The board is composed of 9 members appointed by the governor with the consent of the Oklahoma Senate. The board in turn appoints an executive director to administer the agency. Leadership. The Water Resources Board is overseen by the Secretary of Energy and Environment. Under Governor Mary Follen, Michael Teague is serving as the secretary. Oklahoma Water Rights. Oklahoma has a unique set of water rights statutes based on groundwater and stream water. The owner of land owns the groundwater underlying such land and surface water standing on the land. However, the Oklahoma Water Resources Board regulates non-domestic use. Stream water is considered to be publicly owned and subject to appropriation by the Oklahoma Water Resources Board. Stream water. In Oklahoma, stream water is defined to include water in ponds, lakes, reservoirs, and playa lakes or dry lakes. Stream water is considered to be publicly owned. The Oklahoma Water Resources Board is responsible for appropriation for all areas of the state of Oklahoma except the Grand River Basin, where the Grand River Dam Authority (GRDA) has responsibility for allocation on a use it or lose it basis. Groundwater. Groundwater is considered a property right in Oklahoma and defined as fresh water less than 5,000 parts per million total dissolved solids under the surface of the earth regardless of geologic structure in which it is standing or moving outside the cut bank of any definite stream. The Oklahoma Corporation Commission has jurisdiction over taking, using, or disposal of salt water associated with the exploration, production, or recovery of oil and gas, or to the taking, using, or disposal of water trapped in producing mines. Domestic use. The domestic use of either groundwater or stream water is exempt from permitting. Domestic use is defined as being used by individuals for household purposes, lawns, orchards, and cattle watering up to the normal grazing capacity, plus use of up to 5 acre-feet per year for agricultural by natural individuals, firefighting, and use by non-individuals for drinking water, restrooms, and lawn watering. Federal authority. The U.S. Constitution's Commerce Clause, Article I, Section 8, Clause 3 gives the federal government the authority to regulate commerce among the states. This power impacts water used in Oklahoma for both navigation and for generating hydropower. However, a federal appeals court ruled on whether the Oklahoma laws violate the Commerce Clause. The finding was that the laws do not violate the clause. Texas-Oklahoma laws favoring in-state applicants for water permits were authorized by Congress when it approved an Interstate Water Compact. A federal appeals court has ruled Tarrant Regional Water District v. Herman, 10th Cir. No. 10-6184, 9/7/11. Because the Red River Compact, which apportions rights to water from the Red River among Oklahoma, Texas, Arkansas, and Louisiana was approved by Congress, the Oklahoma statutes did not violate the Dormant Commerce Clause. The U.S. Court of Appeals for the 10th Circuit concluded in its decision of September 7, 2011. The Dormant Commerce Clause refers to previous judicial interpretations that states cannot limit interstate commerce even in matters in which Congress has not acted. By approving the compact, which the court said explicitly defers to and recognizes plenary state authority over water use, Congress gave the states broad regulatory authority in unqualified terms, allowing Oklahoma. The court also rejected claims by the Tarrant Regional Water District, an agency that provides water in north-central Texas, that specific language in the compact intended to ensure that downstream states receive their fair share of water in dry years did not preempt the Oklahoma laws. It affirmed the lower court ruling. This ruling would be definitively affirmed in a unanimous opinion by Justice Sonia Sotomayor for the Supreme Court on June 13, 2013 in Tarrant Regional Water Dist. V. Herman, 569 U.S. 614. Navigation. Because waterways are used to transport goods among the states, while states may claim ownership of the beds of rivers based on the equal footing doctrine, the Commerce Clause established a navigable servitude on all lands and on all state-created water rights, allowing Congress to enact laws that have the effect of overriding state laws on water use. This navigation servitude is described to exist on lands and water up to the ordinary high water mark of streams that are navigable. Hydropower. The Commerce Clause of the U.S. Constitution has also been interpreted to allow Congress to regulate water used for hydropower purposes, and a state cannot refuse to block a hydro project by refusing to issue a water permit, with the exception being through the Section 401 of the Clean Water Act. A state may withhold a water quality certification for the federal hydropower license. Native American rights. In 2010, Oklahoma City, represented by the Oklahoma City Water Utilities Trust OUT, sought to purchase rights to a large quantities of water from Sardis Lake. OUT successfully negotiated approval of this purchase from the OWRB. Many residents in Pushmataha and Latimer counties, where Sardis Lake is located, objected for various reasons. These two counties had previously been part of the Choctaw Nation when the present state of Oklahoma had been part of Indian Territory. The Choctaws claimed that the United States had granted them authority over water resources in their land in the 1830 Treaty of Dancing Rabbit Creek. Prior to the enforced emigration from their ancestral homeland, the national governments of the 5 civilized tribes had been extinguished immediately prior to Oklahoma statehood in 1907. State officials claim that treaties signed by the tribes after the Civil War relinquished tribal rights, and therefore they can no longer make such claims. The state had simply ignored the former nations in negotiating water rights since statehood. In order to halt the execution of the Sardis Lake Agreement, the Chickasaws filed suit in 2011. An article published in the Tulsa Law Review describes the potential legal ramifications for this case if the Chickasaw and Choctaw nations successfully obtain either full or substantial rights to the waters in Sardis Reservoir. Other federally recognized tribes that have water rights not yet formally recognized may have the footing needed to seek legal protection of those rights. If Oklahoma wins this case, tribal water rights could be severely impaired. Interstate Stream Compacts. The entire state of Oklahoma is covered by 4 separate interstate compacts concerning all surface water that flows into or out of the state. These interstate compacts are agreements written by impacted states and approved by the United States Congress. The compacts are the equivalent to treaties between the states in that the rules and regulations of a compact commission, the administrative agency set up to administer the agreements, have the full impact of federal law. Arkansas Riverbed Authority. As the result of a Supreme Court decision, it was decided that 3 of the tribes of Indian Territory were the owners of a portion of the Arkansas Riverbed. The Arkansas Riverbed Authority is an entity created jointly by the Chickasaw, Choctaw, and Cherokee nations to administer the tribally owned stretch of the Arkansas River between Muskogee, Oklahoma, and Fort Smith, Arkansas. To settle pending damage claims, the Congress passed the Cherokee, Choctaw, and Chickasaw Nations Claims Settlement Act, while the original Supreme Court decision dealt with mineral rights under the riverbed. Aspects of the case may impact water rights in the state of Oklahoma. History. Created in 1957, the 9-member board is composed of 1 member from each of 5 congressional districts, with the remaining members at large. Members serve 7-year terms. Members represent recreational, industrial, irrigation, municipal, agricultural, soil conservation, and rural residential water uses. The board administers financial assistance programs to fund eligible public water supply and wastewater treatment projects and improvements. The board also administers water use permits, the water well drillers licensing program, dam safety, floodplain management programs, the Clean Lakes Program, and promulgates state water quality standards. Organization: Water Resources Board, Executive Director, Administrative Services Division Direct Staff of the Executive Director, responsible for supporting the board and providing agency-wide support services, General Counsel Section, Fiscal Services Section, Human Resources Section, Legislative and Media Relations Section, Information Services Section, Financial Assistance Division responsible for providing loan and emergency grant programs to local governments to fund the construction or rehabilitation of community water and wastewater projects. Planning and Management Division responsible for issuing permits for the use of the surface waters and groundwaters, dam safety programs, and floodplain management. Permitting Section, Technical Studies Section, Planning Section. Water Quality Division responsible for collecting physical, chemical, and biological data to protect the public health and safety. Standards Section, Monitoring Section, Lakes and Special Studies Section. Staffing: The Water Resources Board, with an annual budget of about $20 million, is one of the smaller employers of the state. For fiscal year 2011, the board was authorized 101 full-time employees.